We can get started.
Okay. Good afternoon, everyone. On behalf of 4S Consulting and the Ontario Restaurant, Hotel and Motel Association, we'd like to welcome and thank you for joining us today for this very important conversation. As many of you know, summer is a very critical season for the hospitality industry, but with the very short timeline and time season and the urgency that's put on the season, sometimes it's easy to overlook some of the legal responsibilities, especially when onboarding young or temporary staff. At 4S, we've collaborated with over 1,500 organizations across Canada to help meet the Occupational Health and Safety Act regulations and obligations to ensure that everybody is safe at the end of the day and to reduce and prevent harm to our biggest priority, our employees. Our mission is simple. It's to help businesses like yours to embed health and safety into your day-to-day operations and ongoing culture, avoid costly compliance issues, and protect your workers. That's why today the session is so valuable. We've bringing together legal experts to walk us through the must-know obligations, practical steps, and real risks if those aren't met. With that said, I am pleased to introduce our guest speakers today from Sherrard Kuzz, one of Canada's largest employers and labor law firm. Joining us today is Angela Powell. She is a labor lawyer, lead lawyer for workmen's compensation and all aspects of regarding Occupational Health and Safety Act concerns, as well as Victoria Purdy, another labor lawyer who focuses on employment standards and accessibility concerns and issues. I will now be happy to turn it over to Angela, and you can take it away.
Thank you so much. And thanks for inviting us here to speak with you today. So I'm going to speak to obligations and some tips related to workers' compensation and occupational health and safety. And then I'm going to hand it over to Victoria, who's going to speak about obligations and some tips as it relates to the Employment Standards Act and accessibility for workers. So we're just going to put a presentation up here. Here we go. So maybe we can just go forward to the workers' comp first WSIA slide, Victoria. Thank you so much. So just to give a brief overview of the Workplace Safety and Insurance Act, or the WSIA as we call it, as you likely know, being employers in the leisure and hospitality industries for the most part, this industry is mandatorily covered by the WSIA, and so you're required to register with the Workplace Safety and Insurance Board and to pay premiums for your workers. And one of the main purposes of the WSIA and the WSIB is to promote health and safety in the workplace. And as you also likely know, seasonal workers, so those coming into work for the summer, for example, are also covered by the WSIA and are part of your reporting responsibilities to the WSIB. So just moving on to the next slide. This is simply just a visual that illustrates some of the obligations that employers have in the workers' compensation system. I'm going to focus on some of these more than others today, just because I think that some of them are probably, more applicable to what we're discussing today. So moving on to the next slide. One of the key questions that I often get from employers is about reporting accidents. And so an employer is obligated under the legislation to report an accident that occurs in the workplace within 3 business days of learning of the accident. And so, there may be instances where a worker hasn't informed you right away that an accident has occurred. So that obligation kicks in as soon as you're aware that an accident has happened. You are required as an employer to file what we call a Form 7 with the WSIB to report an accident. And in order to know whether you're required to file one, we've outlined some of the attributes of an accident here. So an accident that requires healthcare, that's distinguishable from first aid. So, if someone requires a Band-Aid, for instance, in the workplace, that wouldn't meet the threshold of requiring healthcare. The worker is absent from regular work as a result of an injury that's occurred in the workplace. They earn less than regular pay. They require modified work at less than their regular pay, as an example. And also, if a worker requires modified work at regular pay for more than 7 calendar days following the date of the accident, then these are all instances where an employer is required to file that Form 7 with the WSIB. So there are penalties that the WSIB can charge an employer, and an employer can also be charged with an offense and prosecuted in the event that an employer fails to report an accident to the WSIB. And it's not unusual for there sometimes to be a little bit of confusion with regard to whether a compensable accident has actually occurred. And I always recommend that, if you're not sure, or even if you disagree, it's best to meet your obligation and report the accident to the board, and then object to, make an objection as to whether you believe it was work-related in the discussions and forms that you subsequently file with the WSIB. So I want to talk a little bit about risks to young workers, and you'll see this throughout the presentation just because I think it's applicable to what we're talking about today, in that, recognizing not all seasonal workers are young workers, but certainly, getting into the summer season and hiring a lot of students, there are special considerations, I would say, that I recommend when an employer hires young people into the workplace. And when I'm talking about young workers, I'm generally talking about workers who are aged 15 to 24. And just, a few interesting statistics on this slide. So young workers in Ontario are 3 times more likely to be injured in the first month of a new job than at any other time. And this slide goes on to describe some other numbers, and these are all from the WSIB. You can see that 98 young people actually died because of work between 2012 and 2022. Those are the most recent numbers available from the WSIB. 35,000 young people were injured at work in 2022. And of interest to you, the service sector, so restaurants and retail stores, is actually the top industry for workers, for young workers to get injured in the workplace. So something to keep in mind. That may not, be an obvious sector because it doesn't seem to be high risk, obviously, but common injuries for you to watch out for, to think about when you're training workers or thinking about prevention of injuries, is to think about strains and sprains, cuts, lacerations, bruises, contusions, concussions, those types of accidents that we often see in restaurants and retail stores. So moving on a little bit, I wanted to give you a few live examples of not only accidents that have occurred in the workplace, that, injuries or even fatalities that young workers have suffered, but also talking a little bit about the consequences for an employer who has a worker injured in these types of circumstances. So this first case actually went the whole way to the Court of Appeal, which is a little bit unusual. But a 16-year-old high school student suffered a spinal injury when her hair became entangled in a rotating spindle of a blizzard machine at Dairy Queen. And so, Dairy Queen, I think, you're thinking about it, certainly as a parent, that seems like a pretty innocuous, safe place to work. But unfortunately, the safety guard had been removed from the blizzard machine in this particular case. And the shift leader had actually told the student that, the guard wasn't actually required. And in addition to that, the worker hadn't received health and safety training, so wasn't aware that a guard was actually required on the machine. So if you can go to the next slide, Victoria. So this talks a little bit about the consequences that the employer faced as a result of failing to ensure that the machine was guarded. And you'll see here that ultimately the Court of Appeal fined the employer $40,000 for the injury that the worker had suffered in that instance. Just going forward a little bit more. So I think that, young people, as we know, students, I have a teenage daughter myself, often view themselves as invincible. They have, a little bit of a sense of invincibility. And so I'd recommend that when, doing training for young workers in particular, that you really stress that accidents do happen and they can have, serious consequences. Just my lights have shut off automatically, so I'm turning them back on. Here are a couple of other examples. So I'm familiar with the first one. So a 21-year-old university student was actually electrocuted when erecting an event tent. So he worked at a company that ran events and set up for summer events. And again, it's not something necessarily that you would think would lead to something as serious as an electrocution, but it did. And the second example is a bit of a more famous case. This is Ron Ellis's son, and Ron had become very, very involved in advocacy and workers' compensation and worker safety. And his 18-year-old son died after he was pulled into a mixer at an industrial bakery. And, it's important to note that it was only his second day on the job. And that's something that we see frequently with young workers. As noted before, accidents do happen, and they often happen pretty early on in the employment relationship. So just to give you, a few tools to have at your disposal, also for your own purposes, but also potentially to use as part of your training and to refer workers to. There is a practice safe work link to the WSIB website. It's practicesafework.ca. And this part of the website is specifically aimed at communications for young workers. It guides them with regard to what sort of questions to ask and, what to make sure they know when it comes to their own safety in the workplace. And they're also, the second link here, it's Safety Check Online. And the Safety Check link is also part of the WSIB website, and it's likely of interest to you as an employer, but also as a parent. And so this allows any member of the public to go on to the WSIB website and to search up an employer and to see their safety record. So it's useful for you to know as an employer the types of information that is available on the WSIB website about your company. But again, also as a parent, if you do have a student or a child working this summer. So talking a little bit about occupational health and safety, so it segues nicely into that when we're talking about training. So there are obligations, obviously, under OHSA, which is what we typically call it, which sets out minimum workplace standards and talks about the different obligations of workplace parties to ensure a safe workplace. All employers are required to take all reasonable precautions to protect the health and safety of their workers. And, that includes everything from instructing, informing, and supervising workers. So you need to make sure that you have a supervisor that's competent to instruct and inform. That's something that I often, flag for people. Ensuring equipment, materials, and protective devices are well maintained. If there's PPE that's necessary, protective equipment, ensuring that it's in good, working order, that it's provided to workers so that they know that they need to wear it. And just acquainting workers with the hazards that are in a particular workplace, because they're not all the same in every workplace, obviously. And certainly, workplaces with 5 or more workers are required to have, written policies with regard to hazards in the workplace. And so that's something I'll just flag for you as an employer as well. So this slide talks a little bit about preparing, maintaining, and posting health and safety policies, but these are the types of policies, that you can use when you're training workers, that you may use to, if you want to develop, more detailed or further training material. They really should tie back to what you have in your policies and your legislative obligations. You're required as an employer to post copies of the Occupational Health and Safety Act and a poster that the ministry typically provides to employers. It's useful for you to note that there are certain age limits when it comes to workers and young workers in particular, working in particular environments. So with regard to stores, restaurants, and serving areas, the age is 14, except of course for the caveat of serving alcohol, where a different age limit is required there. And they also have to complete the Smart Serve course and be certified to sell alcohol or serve it. And 15 years old is the age requirement for restaurant kitchens and laundries, etc. There's also a requirement for employers to have written policies and programs to address workplace violence and harassment. I'm not going to get into this slide in a lot of detail, but there are obligations that employers have to review these policies annually and to make sure that workers, when they come in, are informed and educated about their rights and responsibilities as they relate to these policies. So talking a little bit more detail about occupational health awareness and training as it relates to the Occupational Health and Safety Act. There is a specific regulation that we've outlined here, and it talks to in a little bit more detail about what employers must provide to workers and supervisors. And it talks about informing workers about their rights and duties, because workers actually do have duties as well to ensure that the workplace is safe. Common workplace hazards and WHMIS. And so this is something to really turn your mind to with regard to your specific workplace. I often think about, workers in restaurant or hospitality type settings who are involved in cleaning, and using certain chemicals and being knowledgeable about the hazards related to those chemicals. And with regard to the documentation that you're required to keep, you must maintain a record of the training that you provide to your workers. One final point on that one is that just training must be provided unless a worker or supervisor has previously completed a training program. And so if someone tells you I already completed that training, that's fine, but they need to provide you with documentation that contains proof that they actually did complete the training so that you can keep that for your records and to take a look at it and verify that it meets the requirements as set out in the regulation I was just talking about. So again, just special considerations for young or new workers going into the summer season. Young or new workers often don't have any prior work experience. This is, often their first job, first summer job, and they may be nervous about, raising any concerns that they may have. I recommend using a simple language, very clear language about, the health and safety requirements and hazards and things that young workers need to look out for. Even going so far as to clearly communicating and marking equipment that young or new workers are not allowed to operate or perhaps shouldn't operate unless they're under the supervision of someone with more experience while operating that equipment. It's really key to be explicit and to inform, young people in particular about particular hazards related to the equipment they'll be using or the work that they'll be performing, and to ensure that the workers know how to properly use that equipment. In addition to that, I think that, something that young workers are particularly hesitant about is raising safety concerns. So they need to know that if they have concerns about, perhaps equipment not being in good repair, maybe they don't feel like they've been confident that they've been, trained enough to feel comfortable using the equipment. And certainly they also need to know that they have a right to refuse unsafe work. And so I'd recommend being really explicit in your training that part of their responsibility as a worker is to inform the employer, typically their supervisor, if they see something going on that seems unsafe. I think that they need to know that it's not just a theoretical, that it's actually a duty that they have as a worker. And so sometimes that makes them feel a bit more comfortable with regard to coming forward with concerns. This is a reference to the Canadian Centre for Occupational Health and Safety, and they also provide a resource for helping young workers stay focused at work. And they also have a number of other resources that I would recommend. Their website is easy to find if you just Google CCOHS. In particular, I would recommend talking to young workers about distractions, cell phones and headphones, those types of things in particular, and having clear rules in place for the use of those types of devices, being really aware of how much work you're assigning to young workers, particularly at first, if they may not be fully familiar, just to avoid rushing and, potentially increasing the chances of injury. So I recommend taking a look at the CCOHS website. And lastly, cannabis at work. This is just a helpful poster that's also in the CCOHS website that I recommend you take a look at. And it's not just about cannabis, it's about, anything that, including fatigue, that may impair a worker's ability to work, at their full capacity, which increases the chance of accidents happening. And so just wanted to raise that resource for your attention and as something to talk to young workers about explicitly. So I'll hand it over to Victoria. I think I've gone over my share of the time, so
No
I'll hand it
worries.
over to you.
Thanks, Angela. All right, so I'm going to switch gears a little bit and talk about employment standards. So in Ontario, the Employment Standards Act outlines the minimum standards of employment for employees, which does include seasonal employees. It is important for employers to be aware of their obligations under the ESA to ensure that there are no compliance gaps. So we're going to talk about some of those today. But before we do that, I don't want to spend too much time on it, but I think it's worth highlighting the employment agreement itself because it is an important step in the onboarding process. It's really important to ensure that employees are accepting and signing their offer letter before their first day of work. Otherwise, the agreement may be considered invalid. And then in terms of the type of agreement you're offering them, you may be in the habit of signing summer employees up for a fixed term agreement. So for example, one that runs from July to September. If you do have a fixed term contract, it really is important that the employee does not work past the end date without signing on for a new agreement. The consequences of not doing this are that the employee may be found to be working under an indefinite contract, which will change their entitlements with respect to things like termination of employment. If you decide to terminate an employee before the end of their fixed term contract, just keep in mind that you may be on the hook to pay for the remainder of the contract unless you have clear enforceable language otherwise. And then with respect to indefinite terms, which you may also be using as well, under the ESA, an employee who works for more than 3 months will be entitled to 1 week of working notice or pay in lieu of notice. So depending on the type of contract you're using and the length, it is just something to keep in mind there. As always, it's always great to consult with a labor and employment lawyer too, just to make sure you have enforceable termination language in your agreements. Moving on a little bit to some key employer obligations. It can be difficult for employees to understand their minimum entitlements under the ESA, especially for new and young workers who, as Angela said, may not have any experience in the workplace before. In order to remedy this, the ESA obligates employers to provide employees with certain information, which details their rights and requirements under the ESA. So you'll see we've included some of these on the slide here. One of them is that within 30 days of hiring an employee, you've got to provide them with the most recent employment standards poster. And this educates them about some of their rights and entitlements under the Act. This can be found on the Ontario government website. In certain situations, you might also have to provide them with other required information sheets, just depending on the situation. And then this one here is new as of July 1st, 2025. All employers with 25 or more employees must provide employees with certain employment information, which you'll see listed on the slide there. And that should be done before their first day of work, or if not practicable, it will need to be done as soon as possible. And then just flagging really quickly, because we're dealing with the hospitality industry here. I'm sure everyone's aware of the newer requirements with respect to tips and gratuities that came into effect in June 2024. But just practically speaking, depending on your practice for paying out tips, you may need to be having conversations with workers when you're onboarding them about which bank account they want their tips paid into, or if you're paying by cash or check, conversations with them if you're not paying them out in the workplace about where they're being paid and have a written agreement on that. And then, of course, if you have a tip sharing program that includes employers or directors or shareholders, this needs to be posted in the workplace as well. So there's a common misconception that short-term or summer employees are exempt from ESA minimum entitlements, and this generally isn't the case. So I just want to spend a couple minutes reviewing some of the entitlements here. I think the important one to remember is just employees must be paid for time work. So this includes any training or orientation sessions. It also includes any trial periods or any shifts that you're giving them to assess their abilities before they commence employment. Unpaid internships are generally not permitted under Ontario law unless they meet very specific criteria. So we're talking about an approved co-op program that's been organized and approved by an educational institution or a school board. I do, however, note here there is a student wage rate, which may be applicable. It applies to students elementary, secondary, post-secondary who are under 18 years of age and who are working during the summer holidays. So that is something to consider as well. With respect to vacation pay is something that's going to be accruing for your summer employees. But whether or not they're entitled to vacation time is just going to depend on your policy and your vacation year. So if your vacation entitlement year resets during the summer, while your summer employees are on board, they may be entitled to some vacation time. And that's just something to flag for you. And then also mentioning really quickly that under recent amendments, if you're going to be paying vacation pay at any time other than right before an employee takes vacation. So for example, if you pay it out every pay period, you do have to have that in a written agreement now. So something to consider adding to your employment agreements. And then moving on, I've just noted here, I won't go over in detail, but with respect to overtime, just note there is an exception for hospitality industry employers where you're providing room and board, depending on how long or how much of the year the employee is working for. The overtime threshold may actually be raised to 50 hours per week. And then with respect to leaves of absence, just to note as well, seasonal employees aren't going to qualify for every leave. Because some of them will have qualifying periods that are longer than their summer employment. So just be sure to pay attention to the qualifying periods there. Things like sick leave, an employee is entitled to after 2 weeks. So that's something you'll want to keep in mind. And just raising a recent amendment, you can't require a doctor's or a medical note anymore for employees who are taking those 3 unpaid days, although you can require other evidence reasonable in the circumstances. So just something to keep in mind there as well. And then because I'm cognizant of time, we do have this public holiday exception here as well. So just something to consider if you are in the hospitality industry. There are some specific exceptions in here for hospitality industry employees when it comes to public holiday pay too. And then just really quickly, I think it is important to outline record keeping obligations. It's really important for employers to keep accurate records, not just for running your business, but also to protect you in the event the ministry decides to conduct an inspection or an audit, which they can do on their own initiative, without having received a complaint. So employment standards officers have wide-ranging powers. They can require you to produce these records, and they can actually take copies of them with them. And there are penalties for non-compliance. So it is very important for businesses to make sure you're retaining these records and that they're accurate. Generally, they need to be kept for 3 years after an employee ceases to be employed with you. But there are some exceptions as well, and some additional information that's required depending on the age of the employee. So for example, if an employee is under 18 years old, you do also have to record the employee's birth date as well. So just something to consider there too. And then I'll move on just really quickly here to flag accessibility for you. So essentially, the AODA was established to develop, implement, and enforce accessibility standards with the goal of achieving an accessible Ontario by 2025. The important one for us here is the employment standard, which requires employers to make workplaces and employment practices accessible for employees with disabilities. And so employers have some obligations that apply not only during recruiting and onboarding, but also throughout the employment relationship as well. So you'll see here, depending on the size of your organization, there may be more or less that apply to you. But important ones are to remember that when you're making an offer of employment, it does trigger a requirement for you to inform applicants of your policies for accommodating them. And then also once they're onboarded as well, there may be some additional requirements here. Like for example, during training, if an employee asks you to provide training materials in an accessible format, you do have a requirement to do so and to work with the employee to find out what would be an acceptable or a suitable format for that. And then also, as soon as it comes to your attention that an employee has a disability and may need accommodation, you do need to provide an individualized workplace emergency response program or information to that employee in the event of an emergency, and get their consent to share it with any person who might be assisting them in an emergency situation. And then just very quickly here as well, I'll just mention there are some training requirements too with respect to accessibility. So you do have some obligations to provide training on the AODA and the Human Rights Code. And this training also must be done as soon as practicable. And there are certain things that have to be included in it. Luckily for you, employers don't need to develop their own courses. We have some resources here for you. You can go on the AODA or Human Rights Commission website, and they'll provide some free training courses on that. The Government of Ontario also has a nice tool there where you can insert information about your organization, and it will let you know exactly what requirements you need to follow. So just very quickly here to wrap it up, I'll mention also you should keep the training records too. You have some obligations around that. In terms of the takeaways, as you can see, there are lots of different requirements, probably more than you can fit into a 30-minute session about what employers need to follow with respect to policies and information and training. Some things we might recommend is that you develop an onboarding checklist that lists out all of these different requirements, just to ensure that your organization doesn't suffer from any compliance gaps. We might recommend from time to time as well, just performing a self-audit to ensure you're in line with all these minimum standards and obligations. Being proactive about this will give you a chance to hopefully close some of those compliance gaps before an inspection or an audit. And of course, if there's anything you're unsure of, always feel free to give a labor and employment lawyer a call as well, because we can walk you through some of those things. And then lastly, if you take anything from this presentation, we hope it will be to turn your mind to what additional measures you can put in place to help protect young or new workers so that everybody can have a safe, enjoyable, and productive summer. And with that, I know we're a little out of time here, but we're happy to stay around for some questions if anybody has them.
No, we've not received any questions so far.
There's definitely been a lot of information covered today, and I thank you for that. Not only from the checklists and keeping records and some of the minimum legal required training to work in Ontario. I totally appreciate all of that. I'm sure some of it might sound a little bit overwhelming, but they can contact yourselves, or they're more than happy to reach out to 4S. My name is Ruanne, so you can contact us as well for any further information, details, or walking you through some of the steps of any of this. We can just maybe put it out there one more time to see if anybody has additional questions before we wrap this up. Okay, it doesn't sound like anybody's got any questions at this time. So what I'd like to do in closing is to thank both Angela and Victoria for joining us today as our guest speakers. There's been a lot of information that you've covered a lot of ground in 30 minutes and touched on a lot of the important points that everybody needs to be aware of. Truly appreciate your time today. I also would like to extend our thank you to Fatima and Anisha for collaborating with all of us to help get this webinar pulled together today. I'd also like anybody who is on the webinar today, please feel free to reach out to Fatima and Anisha with any feedback and or topics for future webinars that you might like to see or have questions answered. Quickly, health and safety is not a checklist item. It is a legal requirement, and it is people's legal duty to make sure that you hit the minimum compliance and become aware of the information shared today, because not knowing can lead to not so good results in the end. And ultimately, our goal is to ensure that everybody goes home as safe or safer than they were when they arrived to work. So any assistance with, I said, policies, procedures, checklists, training, feel free to reach out to anybody on the panelist. We'd be more than happy to assist. On that note, I would like to thank everyone for joining us, and if there's no further questions, we can let everybody get on with their day.
Thank you so much.
Thank you very
Thank
much
you,
for having
ladies.
us.
Appreciate
you.
It was
it.
a pleasure.
Take care.
Thanks.
Bye-bye.
Thank you. Bye-bye.